I'm Daniel Levine, and this is the Bio Report. Jorge Goldstein trained for a career in molecular biology and biochemistry before becoming a patent attorney, a background that positioned him to help shape patent law for the biotech industry throughout his 40-year career. In his new book, Patenting Life, Tales from the Front Lines of Intellectual Property in the New Biology, Goldstein offers a history of the biotech industry through the lens of the critical patent battles that shaped the landscape. We spoke to Goldstein, founder of the law firms Sterne, Kessler, Goldstein Fox, about the industry's critical patent battles, his new book, and how he's working today to use patents as instruments for social and economic justice.
Hey, thanks for joining us.
Sure. Thanks for having me.
We're going to talk about your book, Patenting Life, how patent law has evolved since the emergence of the biotechnology industry, and your own views as a trained scientist and attorney who's spent a career on the front line of patent litigation. I'd like to start with Niels Reimers of Stanford University and his filing of the patent on recombinant DNA technology developed by Stan Cohen and Herbert Boyer. As you tell the story, it's almost a case of happenstance that Reimers recognized the value of doing this. Can you explain what happened?
Yeah, sure. In fact, in writing the book, I called Niels Reimers and chatted with him. And I also reviewed his oral history at the University of California. And indeed, it was happenstance. But I think it's explained by the culture in the biology world and in the biology laboratories in academia, especially before and after the decade of the 1970s, when it all started happening. There was a great deal of ambivalence about patents in academia at the University of California, at Stanford, at Harvard, at MIT, Michigan, you name it. And this was in the very early years of the 70s. Now, Stan Cohen was at Stanford, and Herb Boyer was at the University of California, and they carried out gene splicing work, and they published their work without thinking about patents. And they published in the Proceedings of the National Academy of Sciences in 1973, and a savvy journalist from the New York Times by the name of McElhenney read the November 1973 paper, and he wrote about it in March of 74. And he, smart that he was, speculated on how this paper by these two people in California might very well open up the world of farming, of medicine, and so on, and that genetic engineering might very well change the biological and medical world. And that is the New York Times article that Niels Reimers read in 1974. So he reads this and he goes, holy cow, there's something here. And he walks over to the biolabs where Cohen is working, and he says, what's this? And Cohen, sort of the old culture Cohen, because Cohen changed. He changed dramatically afterwards. But the old culture Cohen said, yeah, this could be important, and it could go far, but I don't want to patent it. And Reimers said, wait, hold on a second. Let's talk about patents. And he said basically two things to him. One was, if we get a patent on this and license it to industry, there could be a lot of money for your lab. Well, that opened his eyes, because as most scientists working in academia know, it's not always easy to get federal grants. Federal grants for decades have been hard to obtain and renew. So suddenly having another influx of money, perhaps from industry, sounded good. The other argument that Niels Reimers made, and he remembered this when I talked to him, was he said, look, the Asilomar guidelines, now the Asilomar guidelines were guidelines that Paul Berg and a group of ethicists and lawyers and scientists in the early 70s had established after Berg did the very first experiment on recombinant DNA using two viruses. And he created this new virus, and he was worried that he would unleash the demons, right? He was worried that somehow creating new life and new recombinant viruses might bring about viral diseases that would be unstoppable, cancers that would be incurable. And so in Asilomar, which is this place in California, they all sat together, they brainstormed it, and they put in guidelines saying you cannot do this thing unless you use highly restricted laboratories. You need to be very careful what you're doing. You need to put stops into the possibility that these things would run out of control, et cetera, et cetera. Now, the guidelines applied only at the time to federally funded grants because the NIH was involved. And so Niels Reimer's argument to Cohen was, look, if we get a patent and we license it to industry with the condition that they apply and comply with the Asilomar guidelines, we could really apply the Asilomar guidelines to private industry world. That was brilliant on the part of Niels, and Cohen agreed. And the next thing that happened is they went to a pioneering patent attorney by the name of Burt Rowland in California and told him to write up a patent application on genetic engineering. And Rowland did. But because this thing had already published in 1973, and because it was already out there in terms of the New York Times article, the world had basically, the patent law in Europe and in other places in the world had basically blocked the obtainment of patents, except in the U.S. And in the U.S., we have always had a 1-year grace period from publication. So from the November 1973 publication of the Cohen-Boyer paper, they had until November 74 to file a patent application in the U.S. And they did. As if it hadn't been for that New York Times prescient journalist and Niels Reimers, by chance, sitting around reading the New York Times out there in Palo Alto, it would have never happened. And at the end of the day, they only got patents in the U.S., but by the time these patents expired, they had made close to $250 million, $250 million.
It's amazing to think about. You mentioned Paul Berg, who did not seek a patent for his work. At the same time, Kohler and Milstein, who did the groundbreaking work on creation of monoclonal antibodies, that went unpatented. How did all of this give rise to what you call the biological gold rush, and how did it change academic scientists?
Yeah, well, the gold rush started when the world noticed that here was an invention that had been made at Stanford and the University of California that had been patented and had been licensed widely to American industry. But even though there were no international patents, a lot of European companies also took licenses because they wanted to bring products into the United States. So they wanted licenses in the US. And the idea that you could go from a very basic academic invention, which was really, Cohen and Boyer were working with enzymes called restriction enzymes. And these restriction enzymes are able to cut DNA at specific spots. So they were able to show that they could cut mammalian DNA, actually it was frog DNA at the time, and put a piece of frog DNA into a bacteria and produce a frog protein. Now, the frog protein was not very useful, and that sort of led perhaps even themselves not to think widely, as the New York Times guy had done, saying, who wants to make frog proteins? What's the point of that? But the idea that you could take a basic fundamental discovery like gene splicing that worked, and then speculate on what you could do in other areas that were really useful and really commercial, opened everybody's eyes. And then, so there was this aha moment, right? Where, oh my God, you could do this. That's why I consider Bert Rowland to be such a patent pioneer, because he figured it out. And even though it was at a time when the ability of universities to obtain patents based on federal grants was rather limited, that limitation was lifted in the mid-'80s by the passage of the Bayh-Dole Act. And the Bayh-Dole Act basically says, and it works to this day, that inventions made in academic labs or federal labs using federal funds can be owned by the university, and the university has the right to grant exclusive licenses to it. And the combination of the Cohen-Boyer patent, the ability to make $250 million in the years that the patent existed, the ability of Bayh-Dole to allow universities to own inventions, and the founding of Genentech, right, in 1976, showing that here was a company that was essentially financed by Kleiner Perkins, which was a very well-known risk venture capital firm based entirely on genetic engineering. It opened up everybody's eyes, and it led to what I call the biotech gold rush.
The Cohen-Boyer patents were certainly lucrative for Stanford and UC, but my sense is that by and large, patents and tech transfer offices haven't been a gateway to riches for most universities. This hasn't appeared to slow academic institutions from thinking more about translational research and fostering entrepreneurship among scientists, but what effect has the early success of these patents had on universities at an institutional level?
Yeah, I think you're absolutely right. And I agree with you that at the level of individual patents and individual inventions that get licensed, if at all, and bring in money, if at all, the early successes of Cohen-Boyer and others were not easily reproduced, and they led to a sort of an unrealistic expectation, as you put it. On the other hand, it was the sudden merger, as I would say, of the culture of academia that is really focused on fundamental research and discovering new phenomena, and the culture of industry, which is focused on making money ultimately, but producing products and translating the early discoveries of academia into the public markets, creating useful products such as drugs and so on. That is what changed fundamentally. It was not so much the ability to get patents on inventions and licensing them, but it was the presence of industry in the biolabs. That had not been seen before. The chemistry labs were much more familiar in dealing with industrial interest than the biological labs. The biological labs were very much into pure science and discovering how nature worked the chemists had for a long, long time already been consulting with industry, getting patents, and having some money from pharmaceutical companies or chemical companies, the DuPonts, the Grace, W.R. Graces of the world. But suddenly, pharmaceutical companies, big and small, but primarily the big ones at the beginning, started becoming interested in the biolabs and in things going on at the biolabs. A classic example, which I mention in the book, is what was known in the 80s as the Höchst Department of Molecular Biology at the Mass General Hospital. I was a lawyer for the Mass General Hospital in its very early years, and saw and dealt with the negotiation of an agreement where Höchst poured $100 million into an American lab in Cambridge, run by luminaries of the Harvard Medical School and others, just for the purpose of financing molecular biology research. And there were Nobel Prize winners in there. And at the level of individual patents that came out of that project, there weren't that many. But that laboratory, a modern, the Wellman Building in Cambridge, funded entirely by a multinational pharmaceutical company, became sort of the model by which suddenly there was corporate money. And the departments of molecular biology or biology that have benefited from this have benefited not so much from individual patents, but from having corporate funding to supplement, or sometimes, like in the case of the Höchst, I call it the Höchst Department. They hated calling it the Höchst Department in those years. That it was the Wellman Department of Molecular Biology at Harvard Medical School, and people called it the Höchst Department, but the actual researchers didn't like to call it the Höchst Department. And it was controversial too that a German company would be paying for research. But what they did was keep federal money separate from corporate money, so that the limitations of federal funding would not apply to the corporate money. That was an entirely different culture that had not existed before the 70s. And then, of course, as this became common, as it became common to start making inventions with potential commercial possibilities, professors started realizing if they filed patent applications, and the patent applications were owned by the university, but then they got venture capital money and formed a startup, a little spin-off, a startup that spun off the technology that they had invented that belonged to their university, then the venture capital group could help this professor create a startup. The startup would not own, but would take a license from the university on the very invention that the professor had made. The startup would then maybe do a deal with a big international, multinational pharmaceutical company that would take a drug, for example, through clinical trials. And if the drug went through the clinical trials and the startup received a lot of money from the big pharma company, the money it received might have to go into royalties being paid to the original university license. Or, today, a lot of these deals are done where the biotech company actually gives equity to, in lieu of royalties, to the university. So the university ends up owning shares in the biotech startup that was formed by the university professor that's funded by venture capital and by the big pharmaceutical company. You could see how this changed the culture from patents. No, I don't want patents in the 1970s to the contemporary world where this is a large sort of agglomerate of multiple scientific, commercial, and financial interests. It's not been an easy road. Certainly having a professor be the head of a company that's doing research in an area that is generally within the area where the professor is still doing research at the university with federal money has caused headaches to folks that worry about conflicts of interest. But that is that's the world we live in today.
Patent law in the United States has evolved around biotechnology, and the notion of patenting life, as your book is entitled. But I had long thought it was the Diamond Chakrabarty case, a case about genetically engineered bacteria that could break down crude oil and could be patented under U.S. law, that first broached this topic. But there was a much earlier case from 1873 that first looked at this question, involving Louis Pasteur. Can you explain the Pasteur case?
Sure. The Pasteur case was the issuance of a patent. And the first thing I think that we all need to understand is that the issuance of a patent is not a legal precedent the way the Chakrabarty case was legal precedent for the rule that you can patent things even if they are alive, like oil-degrading microbes in the case of Chakrabarty. It was a patent, though, and Louis Pasteur was a real sort of scientific genius. As people may know, or maybe they don't, and I'll remind them, he was one of the first vaccine inventors of the world. He developed vaccines against anthrax, for example, in the 19th century. And he invented the role of pasteurization, which was, it's a common word that we use today for the ability to make sure that milk and cheese and other such things are not contaminated by microbes. He was a specialist on microbes, and even if he had just stuck to pasteurization and vaccines, that would have been enough for a lifetime of achievements. But the man was also a beer brewer. And he knew that America was a great market for beer drinkers in the 19th century. And he had discovered, by painstaking research, that if he purified the beer brewing yeasts that were the Saccharomyces that were used to brew beer since antiquity, right? We're talking 10, 12,000 years. Pasteur discovered that if he purified them, as he says in the 19th century, if he ridded his yeast from organic germs of disease, as he calls it, that he could accelerate beer brewing. That beer brewing would be much more efficient. And so he got himself a patent lawyer, and in 1873, the United States Patent and Trademark Office gave him a bunch of patents. One of them was a patent of brewing beer, and it had a particular claim in it. And by the way, that patent is on the cover of my book. It had a particular claim in it that basically said, I am patenting yeast free of organic germs of disease. Now, I consider that to be the first biotech patent ever. It never was challenged legally, so there's no Pasteur case in the decisions of the case books. But it was a patent on a live being, and it was critiqued by scholars about 25, 30, 40 years later as perhaps not being the kind of patent that should be granted. And if you read the paper by the scholars, a very well-known scholar and director of the Patent Office called J.P. Federico, he said, it's not clear to me that the Patent Office should have issued this patent. And there are two sort of issues that arise with a Pasteur patent. The first issue, and they're very distinct, The first issue is, can you patent things that are alive? Okay, that was eventually answered in 1980. So we're talking 100 years later. It was answered in the Chakrabarty case, which was a case on live microbes that can degrade oil. And the microbes in Chakrabarty were very artificial. They were not natural microbes. So in the popular idea, the fact that something is alive somehow makes it feel like it's natural, right? But genetic engineering and recombinant DNA and the modern biotech revolution has demonstrated that you could create entirely artificial things that are alive. So aliveness does not necessarily equate with naturalness. And so the second question in the Pasteur patent is, okay, so yeasts can be patented. Yeasts free of germs of disease can be patented. But are yeasts free of germs of disease artificial enough? That is the second question in the Pasteur patent. That was not answered. And to this day, it's not entirely clear whether the question of artificiality has an absolute answer the way the question of liveness has an answer. So there are still decisions being handed down in the courts today on the question of artificiality. Chakrabarty did not answer it because, as I said, the bugs in Chakrabarty were artificial. There were no bugs in nature that broke down oil the way the Chakrabarty bugs did. But yeasts free of germs may or may not be sufficiently artificial. And so the question of sufficient artificiality, the hand of a human being in there having made this thing far removed, or at least sufficiently removed from natural things, is still being debated in the courts to this day.
The Pasteur case gets cited by the U.S. Patent Office in 2001 when it issued guidelines that genes isolated from their natural environment were patentable. What was the result of those guidelines?
Yeah, I've always wondered why the Patent Office in the United States issues guidelines on patentability of genes based on a 19th century case on yeasts, which had nothing to do with isolated genes. But the first thing we all need to remember is that the Patent Office guidelines are not the law. The Patent Office issued guidelines all the time about all sorts of things to give advice to their examiners, to give advice to judges as to what the policy of the Patent Office is, to give advice to inventors, to their lawyers. But what the Patent Office says is not necessarily the last word, and the courts have taken somewhat perverse pleasure sometimes in telling the Patent Office that whatever the Patent Office says is not quite what the law is, what the courts say, not what the Patent Office says. So the Patent Office has been slapped in the wrist a few times, and one of the big ones was this one. The Patent Office decided that in this new area of biotechnology, if you isolated a gene from its natural context, namely the genome, and whether the gene was human or it was a plant gene or it was a bacterial gene, didn't matter. If you took the genome, which is, 3 billion nucleotides in length, so it's a huge, very long chain of nucleotides, ATCG, and you pick a few of those, maybe 5,000, 6,000 out of 2 billion, 3 billion, you have isolated a gene, and the gene may be the gene for human insulin, or it may be the gene for human interferon, whatever. So you now have a segment in hand, and the segment, it's not alive, okay? Genes are just molecules. And so, again, applying Pasteur's patent to deciding that isolated genes can be patentable is sort of not quite the right way to think about it. But they said, okay, we will grant patents on isolated genes because isolated genes don't exist in nature as isolated. They're artificial enough. And so they granted thousands of patents on isolated genes. And I mean, even I got, half a dozen maybe, some important genes in isolated form. And the patent office, and those of us obtaining such patents on isolated genes basically thought isolating a gene creates a new artificial molecule that does not exist in nature in isolated form. And therefore, it ought to be patentable subject matter. Well, that went on for quite a long time until the case of Association of Molecular Pathology versus Myriad Genetics, which is known as the Myriad Genetics case, went up to the Supreme Court in 2012. And the Myriad Genetics case dealt with two by now very famous genes, the BRCA1 and BRCA2 genes, which had been isolated from the human genome. And in mutated form, the genes, one or the other, created a risk of breast cancer or colon cancer. And women who had the mutated form of the BRCA gene, well, women or men, had a higher risk of getting cancer, breast cancer, than those who had what is known as the wild type of the gene, which is not mutated. So Myriad Genetics had obtained patents on the isolated BRCA genes. And the thing went up to the Supreme Court, and one of the arguments was, wait a second, the Patent Office has been granting thousands of patents on isolated genes, and isolated genes are not products of nature. They're entirely artificial. And even though the Court of Appeals, by a very famous judge, Judge Lurie, said, oh, sure, the novelty of these genes guarantees that they could be patented because they don't exist in nature. The Supreme Court, by Justice Thomas, in a unanimous decision, except Justice Scalia, who said, I don't understand any of this stuff, so I'm neither agreeing nor concurring nor nothing, just leave me alone. But Justice Thomas wrote a detailed analysis, and he said, look, yes, sure, you've isolated a fragment of the genome, and it encodes for the BRCA gene, and knowing that the BRCA gene has mutations, and you could maybe then use them to diagnose women with the mutation and ascertain the level of risk for breast cancer. All of that is nice and well, but you cannot patent isolated genes because they are nothing but information. Isolating a gene from the genome does not do anything that the gene does not do in the genome. And so Myriad Genetics essentially put an end to the Patent Office habit over the years of granting patents on isolated genes. All those patents on isolated genes that I got became overnight unenforceable and invalidated as not eligible, as having been granted by mistake. And the law of the land is now Myriad Genetics, which is unless you, and the implication of Myriad Genetics was, unless in the isolated form, the product has a new function or does something new that it was not doing when it was in nature, unless that's the case, you can't patent it. You can't say, I have found an antibiotic or a cancer treatment compound in a leaf in the Amazon forest, and I want to patent it in isolated form. You can't do that unless you demonstrate to me, mainly the Patent Office and litigants eventually, that in isolated form, in more purified form, it has a new function. So what we have all learned from this is not necessarily that we can patent things that are found in nature and isolating them, because isolating them takes them out of the natural environment, but we need to demonstrate that they have some new function or form that they didn't have in nature. So one way to do it is the way pharmaceutical chemists and biologists talk about highly purified compounds, for example, that have been discovered in the leaf of an Amazon forest, and that is called the specific activity, which in more common nomenclature would be the potency. So this is a classic example. Taxol was discovered in the leaves of a yew tree growing in the Pacific rainforest in the United States. And Taxol in the yew tree in the bark of the yew tree, is extremely dilute, of course. And in order to provide Taxol to a human being in order to treat a cancer, you would have to have this poor patient eat a tree, or at least the bark of a tree, if not 10 trees, and extracting the Taxol, not just discovering it, not just isolating it, but demonstrating it that in highly concentrated form, it is much more potent. And 1 milligram of this extremely potent Taxol can ameliorate the growth of tumors and cancers, is that precisely that new function or property of the isolated, but not just isolated, the more potent form of Taxol. And that's what people are filing patent applications today on, isolated forms that are more potent, that have new functions, and very few people are trying to patent genes anymore, because we know that that's sort of gone by the wayside.
I want you to just take a step back and in lay terms explain what it takes for something to be patentable.
Well, there are two levels of authority, legal authority on this. One is the basic United States Code. The patent law is encoded by Title 35 of the United States Code. And all of the decisions, starting with an interpretation of the code by the Supreme Court and then by the Court of Appeals. The sum of all of this is that there are a number of basic requirements that are necessary for something to become patentable. So, what can you patent? You can patent either a product, like a drug, or you can patent a machine, or you can patent a process of doing something, a process of treating a human being with a drug, a process of making a drug. And within those categories, products or processes, generally speaking, an invention has to be novel, namely it can't be known to the public in general, anywhere in the world, as, for example, by having it been published before, or a lecture having been given, or just generally available to the public. It has to be well described in the patent application, together with the general state of the art. It has to be enabled, which is a jargon that really means it has to be reproducible by people of skill in the art. It has to be non-obvious. And non-obviousness is a tricky proposition because it changes with time, it changes with technology, but it basically says that if you take your average person of skill, and a person of skill is an entirely mental creation of a person that is generally skilled, for example, in the area of molecular biology, that knows about proteins and knows about DNA. And if that person of skill in the arts would look at an invention and consider it to be beyond the ordinary skill, but actually having benefited from some insight, from some improvement, or having demonstrated some surprising results or unexpected results, then it is non-obvious. And non-obviousness is not an easy proposition to define. It can only be defined by case upon case upon case on a particular area of technology. The Europeans call it inventive step, but it is the area of the law that prevents me from getting a patent on something that's out there already, on which I have done nothing but minimum things. Like, let's assume that you invented a novel door, and I take the door and I paint it green. And I go, well, it's never been green. And that's true. It's novel, but it's not non-obvious. It's not inventive. There's nothing inventive about painting a door green. And therefore, it adds to the basic requirement that something be novel. It adds a little penumbra on top of it, which is, it isn't just novelty, but it also has to be inventive or non-obvious. And in addition to that, you have to name the right inventors. And there's a few other general formalities, but those are the 4 or 5 basic requirements.
I'm wondering about how dynamic a concept that is. If you see the first, say, antibody-drug conjugate, it would seem to me that it becomes obvious you could conjugate lots of things to an antibody and use that as a mechanism for targeting something. So, how much do judges and attorneys have to wrestle with that concept?
Yeah, well, your question is very, very apropos this whole area of obviousness. It is an extremely dynamic concept, and it over the years of the biotech revolution in the last 50 years, it has changed over and over and over again, and it has changed because of 2 major trends. One trend is scientific, and the other trend is legal. So let's talk about the science first. As you well point out, conjugating a drug to an antibody in the early years of biotechnology was a really sort of surprising, wonderful invention where you could have the antibody be like a magic bullet that carried the active drug exactly to the spot in the body where you wanted it, where there was a receptor for that antibody on a cancer cell, for example. And so it was a delivery mechanism. The invention of the whole concept of conjugating a drug to an antibody was really breakthrough. And then what followed from that were a gazillion drugs being conjugated to a gazillion antibodies. And it might very well be that what was not obvious and inventive and perhaps even brilliant in the early years has by now become much more routine. So the scientific developments have led to things that might have been non-obvious very early on to becoming obvious today. And the argument for non-obviousness has become harder and harder. I'm not saying that an antibody-drug conjugate is per se obvious. There's no such thing. But there's an enormous amount of literature on antibody-drug conjugates, and therefore the Patent Office has a lot easier time creating what is known as a prima facie case of obviousness. It is, it's at least presumed obvious, and the burden shifts to the applicant to show that there's something surprising. The antibody was not known. The drug acts 10 times better when it's conjugated than when it's not conjugated. And on and on. I mean, you have the right to rebut the so-called presumption of obviousness. So that's the science. On the other hand, and of course, biotech has become much less of a black box. We understand what's going on at the molecular level much more than we used to 50 years ago when all of these things started. And so the science itself has made more things obvious than there used to be. The law has also responded, not necessarily in biotech, but in general. There was a case in 2007 in the Supreme Court of the United States called Kessler v. Teleflex. In that case, the Supreme Court basically said to us, I'm going to use layman's language, look, too many things are found non-obvious these days, and we're going to put a much higher standard on what is required in order to demonstrate that something is non-obvious. They did this in a case that has nothing to do with biotech, but it has been applied and it keeps being applied in biotech over and over and over again. So the concepts of the KSR case from 2007 have to do with, is there a motivation to do what the inventor has done? And if there is a motivation to do this, is there some sort of an expectation that you will see success? In the early years of most technologies, there are always motivations to do things. There's always motivations in biotech to find new drugs, to create better treatments, to make strange organisms that will do marvelous things. And what has changed is the predictability of the science. And in most technologies, the expectation that you will be able to succeed, which is one of the tests of obviousness, has also become more predictable and easier. And so the Supreme Court in KSR reminded everybody that motivations to do something should be found in all kinds of things, the needs of the market and other such things. And expectations of success, which are the other part of analysis of obviousness, could also be decreased a little bit. And so together between the advance of the science and the advent of things like KSR and its progeny in the case law, we live today in a world where, when I started as a young patent attorney, there were a lot more things that were not obvious than today. Today, a whole universe of things have become much more obvious.
One thing you don't get to touch on in the book is the emergence of artificial intelligence and generative AI. But I'm wondering how you expect that to impact the biotech patent landscape, and particularly the idea of what's thought of as being non-obvious.
Yeah, I didn't touch upon AI mostly because I've never had a case on AI. The last 50 years didn't have AI. AI started in the last 2-3 years having an impact on the patent law, and we've had very few, if any, decisions. We've had a lot of guidelines. The Patent Office has issued guidelines, and but there's been very, very few cases on applying AI to patents in biotech. Now, there is a very famous case from the Court of Appeals that basically said that in order for you to name somebody as an inventor, it has to be a human being. You cannot name artificial intelligence as an inventor of anything. Now, all of us working in the field know that AI has the ability to invent. There's no question about it. I mean, if AI scrapes the literature of the world and then you ask it to come up with a new drug that will do XYZ, that will fit into a particular receptor, that may have a therapeutic effect as an analgesic, etc. It'll just go into the literature, find all the analgesics, find those that fit into a particular receptor, and then modify it in some way and test it in silico, as we say, right, in a computer system, and invent a new drug. Well, you want to patent that, you won't be able to, because it was invented by AI. And so we are all scratching our heads. Should we let AI invent? And my view is, yeah, of course. Why shouldn't we? But what do we do about the fact that if it invents something, you can't get a patent on it? That is a big quandary, and it's not yet being approached. And it could be that at some point, we'll be able to convince the legislator to change the law and overrule the decision from a few years ago saying, yes, you could name AI as a co-inventor. But at this point, you can't. And not only that, you have an obligation, a duty of honesty and good faith to the patent office. So you can't just name yourself as an inventor when in fact the invention was done by your AI program. That would be fraud on the patent office, and your patent could in fact be rendered unenforceable. Now, how about trying to answer your question on AI and obviousness? I think AI has the ability to dramatically increase the state of the art. I have already seen, and this was before AI, but I have seen in my career people generate prophetic papers that describe all kinds of technologies that have not yet been done, but that are predicted to be possible. And I think AI is able to do that. And I wouldn't be surprised if there are people who are sitting around the clock generating technology on how to cure this disease and that disease, et cetera, et cetera. All of it is prophetic. All of that will increase the amount of what we call in patent law the prior art, the state of the art, the publications. And some of it will probably be bogus. Some of it may very well work. The burden will be on applicants to show that this technology generated by an AI program is bogus, that it doesn't work as described, and therefore cannot be used to render something obvious. And so AI is not so much going to make more things obvious, but will increase the level of skill, will create layers and layers of state-of-the-art that don't exist and that are basically going to exist only because of the imagination of a computer program, and will perhaps at some level make it harder to get things patented as non-obvious because the level of skill in the art has grown so much. So it's going to come more from there than AI making inventions, which they will. There's no question in my mind. The other area where AI may have an impact is in this sort of definition of what we call the person of skill in the art, which I described before, this hypothetical person that knows everything there is to know about molecular biology, but it is only of average skill, so it doesn't quite invent. A person of skill in the art may increasingly become defined by a person of skill in the art having access to the latest AI technology, so that it's no longer the person alone, but it's the person with a collaborator, namely a computer. I think the definition of a person of skill in the art, taken together with advances in AI, will also increase the level of skill as the law sees it, and maybe make things more obvious than they have been. Lucky for me, this is all the next generation of lawyers. I've dealt with my share of problems, and this is I always tell that to my young lawyers in the office. I go, this is your baby now.
Patents are often blamed for not only the high prices of drugs in the United States, but in particular in the developing world. You discuss the industry's mishandling of the AIDS crisis in Africa, and one of the effects it's had on you was to create a pro bono patent practice within your firm. I'm wondering if you can explain the thinking here and how you envision patents being used as instruments for social and economic justice.
This is dear to my heart. I created this pro bono practice about 15 years ago, and I thought that there was a way to allow the use of the patent system as we know it, as we patent attorneys in the developed world know it, European patent attorneys, American patent attorneys, Canadians, increasingly Chinese patent attorneys, who understand how the system functions, but to represent folks in the developing world, folks who are in impoverished areas, who do not have access to good international lawyers like we are, who don't have money, who are impoverished. So the concept of pro bono, which is a time-honored, traditional practice of lawyers serving their communities when it comes to things like elder law and poverty, employment, landlord-tenant, could now be used, in my view, in the intellectual property context by offering legal services to use and take advantage of the patent systems of the developed world to impoverished and underrepresented, disenfranchised communities. This is part of what I call the United Nations Covenant on Economic, Social, and Cultural Rights. The ESC rights are not the basic political rights that we all know of: freedom of speech, freedom of assembly, freedom of religion, etc. These are economic bill of rights, as Franklin Delano used to call them: the right to development, the right to health, the right to clean water, the right to clean air. And there's a United Nations Covenant on Economic, Social, and Cultural Rights. Among them is the right of authors to benefit from their creations, their inventions, their original art, etc. So I thought, well, why don't we create a practice in which we can offer top-of-the-line services on the patent systems of the developed world to underrepresented communities. And I focus primarily on indigenous communities, tribal groups in Latin America, tribal groups in the United States. And I have had a number of very interesting clients that have taken advantage of it, and we have filed patent applications and obtained patents. And the patents are then, as patents are, used as assets. They are offered to companies. Companies will then pay for access to the patented inventions. If they're useful to them, they will take a license and they will pay royalties. And that flow of money would then go from a company that is exploiting the invention under license back to the tribe. And so I've called this concept reverse tech transfer, because the classical tech transfer is from the big the big pioneering pharmaceutical and other technological multinationals of the developed world into the developing world. It flows from the north to the south, generally speaking. My idea is that the flow is reversed, it goes from a tribe, the technology goes from the tribe up to the north, and money flows back to the tribe. And I've had some successes, and I've been very happy with it. And I could tell you one or two if we've got time. And the one that is close to my heart because it's just breaking open now is representing Lucas Tyree, who is a member of the Monacan tribe of Virginia, a very impoverished tribe that was mistreated by the state of Virginia for many, many decades during the Jim Crow laws. The state of Virginia classified this Native American tribe as African American, if you could believe this. And they classified them as African American so that perversely they could discriminate them against them under the Jim Crow laws. So that Native Americans of many tribes in Virginia, but the Monacan tribe, like Lucas Tyree tribe, were not allowed to go to public hospitals, to public schools, to sit in the back of the bus, and on and on and on, until the civil rights laws of the 60s finally ended Jim Crow. Well, he had been the first one of his tribe to go to high school. He then went to the University of Hawaii, and he then went to Yale. And he became an expert on plants and vegetables, and he invented a formula and a method of feeding plants that are growing in just plain water with no nutrients coming in through the roots, and all of the nutrients being sprayed on the leaves together with a penetrant, a compound that allows the minerals to go through the leaves into the plant, and they grow normally. And you can have leafy veggies like spinach or lettuce, for example, fully developed by just feeding them through the leaves, growing in plain river water, for example, clean river water of the Blue Ridge Mountains. And we just got into patents in the last month. And I'm talking to hydroponic companies right now to see whether they're interested in adapting their systems to essentially pure foliar feeding, as we call it, feeding through the leaves where the plants are growing in plain water. And if that works, then Lucas will benefit from this reverse tech transfer, an invention he made, licensed by big companies, leads to money flowing back to him and his tribe. And he would like nothing more than to take some of that money and buy back some of the land that the state of Virginia stole from his family, and that the KKK hounded his family away from where they were living ancestrally since the 17th, 18th century. So Lucas is a good example of this reverse tech transfer and how the pro bono work could be used to benefit disenfranchised. The pro bono program using intellectual property and patents can be used to benefit disenfranchised and impoverished communities.
Well, you've lived through a lot of key rulings and notable changes to patent law. Do you see the need for any reform?
Well, reform is an interesting concept for me because I represent all kinds of clients, and I have represented over the years big pharmaceutical companies and small startup companies and individuals, and now in the last 15 years or so, underrepresented pro bono clients. So my sense of what is necessary in order to make the patent system better has two sides, right? One is, how can it make it better for the big pharma companies so that they will continue making these wonderful inventions that they make? And yet, at the same time, how can I make the system better so that it benefits more people per capita, right? How can I make it so that perhaps the prices of biological drugs, which are the wunderkinds of the world today, right? The biologics such as the mRNA vaccines that were used for COVID, or biologics such as Enbrel or Humira or others, become more accessible. And accessibility of drugs, both in the United States and abroad, and the price of drugs, both in the United States and abroad, are as much an important part of what I consider a well-balanced patent system as making sure that we can get the strongest possible patents so that our very creative research community continues developing and creating these wonderful drugs that they're creating. So for me, it's a balancing act. I would say that not everything that makes patents weaker, for example, is necessarily bad for the public, as the big pharma PR departments would like us to believe. Conversely, not everything that makes patents stronger necessarily is immediately good for the public, even though the argument always is, well, the public benefits from us making more drugs, and if you make patents weaker, there will be less drugs. Okay, I hear them, and pharma has a very strong voice. My sense is that there are areas in which, without causing major pain to the big pharma world, it could be made more accessible to the general public. For example, one of them is the Biologic Price and Innovation and Competition Act, which is known in jargon as the BPCIA. That's the law that was enacted a few years ago to make it easier to place copies or equivalent copies of biological drugs, such as interferons and TPA and mRNA vaccines and so on, into the public as the second comers, right? So there's an equivalent system in the pharma world, small molecule pharma world, which is the Hatch-Waxman Act. The Hatch-Waxman Act allows generics to create bioequivalents to the brand name drugs and then come into the market with much less expensive drugs. And a similar system, but not entirely the same, was created for biologics. And the biologics are powerful drugs with few side effects. Monoclonal antibodies for all kinds of things are the classic example these days. The only thing that they did very differently, unfortunately for the public, okay, not so bad for the biotech industry, but for the public, was that they created a 12-year clinical data exclusivity before the second comer, the biosimilar company, can use the clinical data of the originator, of the brand name company. In the Hatch-Waxman Act, which is a small molecule equivalent of this law, which has been around for many, many years, the data exclusivity for the use of clinical data of the brand name company is 5 years. Well, when the Biologics Price and Competition Act was passed, they tacked on another 7. So clinical data exclusivity for a biologic is 12 years. That's 12 years before a biosimilar company, I don't want to call them generics, but they're sort of the equivalents of a generic. They're not identical, but a biological generic, as it were, can come and use the clinical data of the brand name company, has to wait 12 years. Well, it might as well be that if somebody wants to come in with a generic of a biological, biosimilar, they might as well go off and do clinical trials on their own, because 12 years is a long time to wait before the drugs can be copied and brought into the marketplace. So I would go there. I would try to decrease the 12-year data exclusivity to something more like 5, 6, 7 years. I don't know. I don't think it's going to happen in the next 4 years.
The book is Patenting Life, Tales from the Front Lines of Intellectual Property in the New Biology. Jorge Goldstein, author and founder of the law firm Sterne, Kessler, Goldstein Fox, and director in its biotechnology and chemical practice group. Jorge, thanks so much for your time today.
Thank you very much for having me, Daniel. And I look forward to more conversations. Bye-bye.
Thanks for listening. The Bio Report is a production of the Levine Media Group. To automatically download this podcast each week, subscribe to our RSS feed or through iTunes or other podcast manager. To join our mailing list, go to levinemediagroup.com. We'd love to hear from you. If you want to drop us a line or are interested in sponsoring this podcast, send an email to danny@levinemediagroup.com. Special thanks to Jonah Levine, who composed our theme music, and the Jonah Levine Collective, which performs it.